Good morning, everyone. Thank you for joining. My name is Christy McKenzie. I am the Assistant Coordinator of Neighborhood Services in the Erie County Department of Senior Services. Welcome to the 2020 Elder Law Day Virtual Summer Series. This series will run every Wednesday through the end of September, and you can visit our website at erie.gov/ELD to register for upcoming sessions. Please feel free to ask questions during this presentation. You can use our Q&A panel off to the right. We just ask that you refrain from submitting any personal information in those questions. This presentation will be recorded, so you can find it later on our website to review it. Also, the PowerPoint will be available as well. I would like to take a minute to thank those individuals who have helped make this summer series possible, including our County Executive, Mark Polenkars, Karen Nicholson, the CEO for the Center for Elder Law and Justice, and our Senior Services Commissioner, David Shane. Please allow me to introduce our guest speaker. Anthony Kuhn is a managing partner at Tully Rinckey and serves as the chair of the VAEC Committee on Veterans and Service Member Legal Issues. He has served more than 24 years in the U.S. Army. Anthony Kuhn practices areas include corporate, labor and employment, military law, national security representation, and veterans benefits. He is also the co-founder and co-director of the University of Buffalo School of Law Veterans Law Practicum. Welcome, Anthony.
Thank you, Christine, and thank you for the invite. I appreciate the opportunity to be here, speaking with everybody today, so thank you for that. All right, we'll go ahead and get started here. I just want to make a quick note that this is going to be a discussion geared specifically towards service-connected compensation claims. If you have any other veteran law-related issues or any other questions that I might be able to answer, feel free to follow up with me offline about those issues, and I'll be happy to discuss them with you. So we have quite a few slides to get through here in the presentation. I thought that it would be better to keep the presentation intact. It's really designed for a 2-hour CLE. We'll get through as much of it as we can in about an hour, and you will all be provided with the PowerPoint presentation. The reason why I didn't want to cut slides out is because there is valuable information contained within the PowerPoint presentation, so I think that it would be more beneficial to provide the presentation as is. So we will go ahead and get started. So some of the topics that we're going to discuss in this presentation today is just basic eligibility requirements and initial consideration for service-connected compensation. We'll talk about a couple of different types of benefits, specifically service-connected compensation, how to apply. We'll talk about denials and how to appeal those denials. We'll talk about how to determine the degree of disability, and along with that, how to determine how much money that veteran should be receiving for that disability. And then we will briefly touch on the military sexual trauma claims, which have come a long way recently. This is just the basic flow of how a service-connected compensation claim would work. So the initial application would start at a regional office. Here in Buffalo, we actually have one on Elmwood in Buffalo. But it starts at the regional office, and then if the veteran isn't able to obtain the relief that they're requesting at that level, there would be an appeal. The next level of appeal is basically the Board for Veterans Appeals, and there are a couple of opportunities to attempt to fix it before the Board of Veterans Appeals, which we'll talk about later. But that is really the next level of review, is the Board of Veterans Appeals. After that, the Court of Appeals for Veterans Claims. We'll talk in a little bit of detail about that later in the presentation as well. And then rarely a claim can go on to the Federal Circuit or to the Supreme Court, but that happens very rarely. So the definition of a veteran, everybody has their own definition of what they think a veteran is. In my opinion, a veteran is somebody who puts the uniform on and made an attempt to serve their country. It doesn't always work out. But I prefer to refer to an individual who made an attempt and showed up and regardless of their classification of service, I would consider that individual a veteran. The government doesn't see it that way. For the purposes of compensation and for other benefits, the veteran has to have some type of active duty service in one of the 6 branches, and they have to have been discharged under conditions other than dishonorable. And we'll talk about there are a number of different types of discharge or classifications of service that can be assigned. We'll talk about each of them in a little bit of detail so that you have a good understanding, and there's a breakdown in one of the slides to help you as well. Again, the individual would have had to have served in one of the 6 branches, and that includes reserves or National Guard if that individual has had any active duty time. So these are the types of discharge, what you'll hear classifications, discharge classifications or classifications of service. It's the same thing. So the different types of discharge, the best one is obviously an honorable discharge. The next one is a form of an honorable discharge. We call it a general discharge, but it's a discharge under honorable conditions. And then from there, you start to get into the dishonorable discharges. And the first one is an other than honorable, or what you might hear referred to as an OTH. And then there's an undesirable discharge, which we don't see very often anymore. Bad conduct discharge usually means that the individual was court-martialed. And there is a dishonorable discharge, which again, we don't see very often anymore. These have changed with time. This is just a simplified breakdown of what types of benefits an individual might be entitled to based on his or her discharge classification. First one, honorable, they're usually entitled to all benefits. The next one is the under honorable conditions, what we refer to as a general. That one, the veteran, there are a lot of different types of benefits that apply, but again, we're talking mostly about service-connected compensation here today. So for the purposes of service-connected compensation with the general discharge, the veteran will collect that monthly paycheck if they have a condition that is deemed to have been service-connected. What they won't collect is they won't collect education benefits. So GI Bill, things like that, they won't get those benefits. They'll need an upgrade to an honorable to get those benefits, or a prior period of honorable service. The next one down is an other than honorable discharge. For any of these forms of dishonorable discharges, they will not be able to collect that service-connected compensation claim, that monthly paycheck, but they can get treatment for a service-connected condition. So if I hurt my knee, I got kicked out with an other than honorable discharge. If the VA comes back and says that it is service-connected, that 10 or 20% that they would have given me means that I'm not going to get the monthly paycheck, but they will treat me for my knee if it's a service-connected condition. And there are ways to upgrade these dishonorable forms of discharge. There's 2 different ways. We'll talk about them a little bit later in the slides. So in order to qualify for service-connected compensation, the injury must not have been caused by willful misconduct. In other words, the veteran didn't inflict this injury upon themselves intentionally, or it wasn't a result of some type of intentional wrongdoing. Some obvious examples: the veteran shoots himself in the foot because they don't want to be in combat or something like that. Obviously, they're not going to get service-connected compensation for that. And then alcohol abuse, depending on whether it's secondary, can actually be considered willful misconduct. If it is secondary to PTSD or another service-connected condition, then it will not be considered willful misconduct. So in and of itself, alcohol or substance abuse is willful misconduct, but if it's secondary to another condition, it is not willful misconduct. And again, you'll see throughout the presentation here that I put the specific statutes or where the citations to make it easier for any of you who might be practicing in this area, so that you can, hopefully find some value in the slides and use them in your claims. Alcohol abuse, as I said, is considered a form of willful misconduct if it's not secondary to a service-connected condition. Same thing with drug abuse. An odd one that comes up sometimes is residuals of venereal diseases. That is not willful misconduct. And then suicide is not considered willful misconduct. And this is how they word it: so long as the deceased veteran was not of sound mind at the time of the suicide. So in my opinion, it would be very difficult to prove that somebody who just committed suicide was of sound mind when they committed suicide. So you should be able to get that compensation claim through. Now, a lot of times I get asked, who can represent a veteran? Do I have to be an attorney? You do not have to be an attorney to represent a veteran for a service-connected compensation claim, but it is much easier to be accredited by the Department of Veterans Affairs if you're an attorney. If you are a VSO or somebody who has not become an admitted attorney, you have to take an exam, and it's a very difficult exam. I took it back when I was a law clerk a while back, and I started to take it, and then I just decided to wait until I got admitted because it's a very long application process as well if you're not an attorney. If you're an attorney, what you would do is you would just submit proof that you're an attorney, you're a member of a state bar, you fill out a VA Form 21A and you submit it to the Office of General Counsel. You can scan it right in and submit it by email, and you don't have to submit the CLE, the proof of the CLE with it, because you can't do your first CLE until after you get accredited. So if you go and do a CLE to become accredited, that CLE is not going to count. You'll have to do the CLE again within the first year of accreditation. But once you submit that application by email, it can be 2 days or it can be a couple of weeks, depending on how busy the attorneys are or the reviewers at the Office of General Counsel. I've seen some attorneys here at the firm submit on Friday and get their accreditation on Monday. Some have had to wait a couple of weeks or a couple of months, and then usually if they follow up, they get the accreditation right back immediately. So again, for an attorney, very easy. If you want to represent a veteran, you have to fill out a VA Form 2122A, which is essentially a power of attorney. So you fill that out and you submit that to the Office of General. The rules have recently changed on where you're supposed to submit the retainer agreement and the VA Form 2122A, which is essentially the power of attorney. You used to have to submit to multiple locations. Now you should only have to submit them to one location. It should be the regional office. So, well, just a warning on the 2122A. Make sure that you're careful where you sign. If you are an attorney and you are taking on the case either on an hourly retainer or a contingency fee, you want to make sure that you only sign the second page. If you sign the first page, you are basically locking yourself into pro bono representation. And it happens. I've seen it happen quite a few times where attorneys didn't realize what they were signing. It was not as clear on the older VA 2122A. On the newer one, they've made it a lot clearer. So just make sure that you pay attention to the sections that you're signing on that form. So what is service-connected? Service-connected is basically any injury that was aggravated or incurred while on active duty or in the line of duty. That's a simplified definition, but here is the the actual definition with the citation. So a prima facie case for a service-connected compensation claim, you have to be able to satisfy three things. The first is that there has to be a current condition. So it doesn't really matter if the condition continued from the time that the individual got out of the military. It could have been that they got out of the military 5 years ago. They now have a disability. Again, we'll go back to the knee. So the knee is sore, loss of mobility, not able to bend the knee as far as you used to be able to, maybe not able to run anymore. And it didn't bother the individual immediately, but we had this delayed onset. Now the knee is bothering the individual. So now we have a current disability. That satisfies the first element. The second element is that there was some type of in-service occurrence or aggravation, some type of knee injury while on active duty. So that if we can show proof of that, and there's a number of different ways we'll get into here shortly, that would satisfy the second element. And then the third is that we have to be able to draw a nexus between the two. So some type of relationship between the two. If we have a left knee injury that is current right now, a condition, a disability, and we had a documented left knee injury while on active duty, it should be very easy to draw the nexus between the two. And then that's going to be your prima facie case for the service-connected compensation claim. So we'll talk about a couple of standards that the VA uses. This one is, in my opinion, the most relevant, the most important, and that's the benefit of the doubt doctrine, which they have written in decisions in many different types of languages. I call it the benefit of the doubt doctrine. In other words, the benefit of the doubt goes to the veteran. So if there is at least as much evidence that the injury was caused and is service connected as there is that it wasn't, then the benefit of the doubt goes to the veteran. And I know that sounds confusing, so I wrote it a couple of different ways here. So when there's a balance of positive and negative evidence, the benefit of the doubt goes to the veteran. And down here at the bottom, you'll see what the language that you want to see in the medical records, which is it's at least as likely as not that the condition was aggravated or incurred while on active duty, or that it's related to the military service. So just in a little bit more detail, the prima facie case. So we talked about the number one element, which is evidence of a current disability. And for that one, you'll need some type of medical diagnosis. We'll talk about military sexual trauma, but this is a good example that I use sometimes. A military sexual trauma is an experience. It's not a diagnosis. So you need some type of medical diagnosis. And we'll talk a little bit more in detail about that here shortly. But you need a condition or a disease or an injury. So you need PTSD, you need a knee injury, you need a back injury, you need some type of actual medical diagnosis by a doctor. And that's where you're going to get that disability from, that current disability from. And they use the language competent evidence. But if you have medical records showing that there's a current condition, that's going to satisfy the competent evidence standard. And down here, I've listed a few different types of evidence that you could rely on. The obvious one is your VA medical records, and private physician medical records are admissible as well. And as well as layperson evidence in most cases, they just carry less weight. There was a recent change that pain itself can be service connected. You can't pyramid, so you can't tack pain on to another condition. They'll rate the higher of the two. But if it's pain that can't be associated to a specific injury, then the VA will sometimes actually grant service-connected compensation for pain. Gulf War syndrome. This has been going on, I believe, since 1991. It's a helpful tool for individuals, veterans who are coming out or have come out of the military in the past couple decades. It's very helpful in establishing claims because you can put it through as a presumption case if the individual was deployed somewhere that would qualify for Gulf War syndrome. And it could be something as simple as chronic fatigue with no actual diagnosed medical condition. That's going to be a presumption case or a condition that was presumed to have been caused by that individual being in a certain geographical location. And as a result, they will likely get their service-connected compensation claim granted because of that. So it actually works out better for the veteran if there is no specific condition. And we'll talk about that a little bit more in detail, I believe, on one of the next few slides. All right, so the second requirement, which we briefly touched on, is that there's evidence of an in-service occurrence or aggravation. So what I mean by occurrence or aggravation is that the injury could have been caused while the individual was on active duty, or the individual could have joined active duty or the military with a certain medical condition that they deemed was not severe enough to limit that individual's ability to perform the duties of their job. So if you join the military with a medical condition and it worsens while you're in the military, that's where the aggravation comes in. So it does not have to be directly related to military duties for the aggravation claim, as long as the condition worsened while that individual was on active duty. Again, lay evidence can be used to help to establish the claim. That's a form of evidence that the VA will consider, and that could be lay evidence from the veteran. That could be buddy statements. That could be, the family member, sometimes a spouse or a parent will submit a statement as well. That's all forms of evidence that will be accepted and considered in the claim. These are some exceptions. There are a few exceptions for combat veterans. Sometimes the evidence is going to be more considered with a more liberal standard. Sometimes evidence will be given a little more weight if the individual is a veteran, and here are some of the circumstances under which that might happen. So the lay statements that are going to be submitted by the veteran, they're going to be assigned more weight if the individual was engaged in combat with the enemy. And that's where the condition comes from, or that's where the veteran is claiming that the condition comes from. they're going to want to see that it's consistent with the circumstances and conditions or hardships of that service, that military service. And they want to see that there's no clear and convincing evidence to the contrary. If there's no clear and convincing evidence to the contrary, then they're going to accept that as good evidence, and that will help the veteran to establish their claim. Again, we talked about the need for actual medical evidence. You need that disability, you need that medical condition, so you're going to need medical evidence to support that. And this gets back to that benefit of the doubt doctrine that I talked about a few minutes ago. You're going to want the records to show that it's as least as likely as not. And it doesn't matter how many times you say that phrase, you're going to get caught up saying it because it just sounds confusing, but it's at least as likely as not caused by the service connected, the service or the active duty time. So these are some nexus theories. So again, we said first element, current condition. Second element, you had to have a condition that was aggravated or incurred while on active duty. And the third for that prima facie case is the nexus. These are some of the nexus theories that are used. You can claim multiple theories. You don't have to claim just one. So it's helpful if you claim more than one, throw them all in there and see which ones stick. The first one is the obvious one, the direct service connection. And sometimes that can be what we call a delayed onset claim. That was the example I gave earlier. The knee didn't hurt for a few years, now it hurts. That is still going to be a direct service connection because you have an injury now, an injury in service, and you can easily tie the two together. There's some type of nexus. Second theory is going to be aggravation. So that's the individual came into the military with a condition. Doesn't matter if a specific thing in the military caused that condition to worsen. All that matters is that the condition did get aggravated or worsen while that individual was on active duty. It's presumed to have been caused by that military service. The next theory is a presumptive service connection, and that is, the service that is the Gulf War syndrome, that is Agent Orange, that is contaminated drinking water, things of that nature. There's all different types of presumptions. The next theory is a secondary service-connected condition. So that is as a result, I'll give you an example, as a result of your knee condition, you're limping, which then causes harm to your hip over time and causes hip pain or causes a hip-related condition. That hip-related condition is now a secondary condition because it's secondary to the knee injury, and it is a compensable condition now. That individual can collect compensation for that hip condition as long as they can show that it is secondary to the knee condition. They didn't have to have a hip injury while on active duty or anything like that because they have the established knee condition. It just has to be secondary to a service-connected condition. And then the last, or one of the other theories, is essentially a medical malpractice claim. It's an 1151 claim. Now there's been recent changes, less than a year ago, where these types of federal lawsuits are now able to move forward for medical malpractice for veterans. In the past, they weren't able, under most circumstances, they weren't able. The Ferris Doctrine prohibited suing doctors in the military for medical malpractice claims, and the way that you got around it was an 1151 claim. 1151 claim might also apply if an individual is injured at the VA. Could be some type of negligence. They could be injured in the waiting room. Anything that happens as a result of that treatment at the VA could also fall under an 1151 claim. So I'm going to go through these kind of quickly because I don't want to spend too much time on them. I think I've already talked to them a little bit, but the direct service connection is, the one that the one that we all think of. Just the injury was aggravated or incurred on active duty service. You have a condition now, and you can draw a nexus between the two. Delayed or direct service connected, I talked about this. This was the example I gave for the knee. The condition was aggravated or incurred while on active duty. Then it didn't hurt for a long time, but now it hurts. You can still get that delayed onset that is a direct service connected claim. Second type of theory, the second theory for the nexus is aggravation. We talked about this a little bit. So there's a presumption of soundness. An individual comes into the military, they're presumed to be sound. It is a rebuttable presumption. They're presumed to not have any medical conditions, but if they do have a medical condition when they join, it just has to be aggravated. It doesn't have to be tied to anything. And these are presumptions of aggravation. This is the case that applies for the citation. If you ever want to use this one, hopefully you find this helpful in any of the work that you're doing. And just one other note, it has to be more than a temporary worsening of the symptoms. So it has to be an actual disability. It has to be at the time that the claim is filed, it has to be a disability or a condition at that time. If it gets better by the time the claim is adjudicated, which sometimes can take 5 years, if it gets better by the time the claim is adjudicated, you don't have to withdraw the claim. If the condition existed at the time that the claim was filed, the veteran should be paid for that period of time, and then it would be cut off at the time when that condition improved or got better or no longer was a disability. So continue the claim. We've talked about some presumptions. I'll get into more detail here. So radiation is one form that causes some presumption-related conditions, and there's a specific enumerated list. Herbicides and dioxins. So the one we are all mostly familiar with is Agent Orange. That has been, there's hundreds of thousands of veterans who have had presumption claims related to Agent Orange, and there are many different conditions that, again, were just recently updated. So all different types of cancers and other diseases that you can tie to Agent Orange. Gulf War syndrome, we talked about that one already. There is an enumerated list of symptoms, but it's symptoms, it's not conditions. So if they have a certain symptom, that could potentially be tied back to the Gulf War syndrome, and the individual could get service-connected compensation for it, even though it might not be tied to a specific diagnosed medical condition. I hope that makes sense. And then you have Camp Lejeune water contamination. Again, this one was recently expanded to areas outside of Camp Lejeune, but they're water contamination cases. We talked about secondary conditions. So that is, you have a primary or a service-connected condition, and you develop another injury as a result of that initial condition. That second condition or secondary condition can be service-connected if it can be tied back to an original service-connected condition. And again, a lot of veterans don't realize that they can be compensated for developing a new condition. It could be 50 years after they got out of the military. Anytime in their life, if they have a condition that can be tied to a service-connected condition, then they can increase their service-connected compensation by filing for that condition. And then we talked just briefly about the 1151 claims. Again, this can be some type of misconduct in the military, at a Department of Veterans Affairs office, at a VA hospital. It's a kind of a workaround for the Federal Tort Claims Act, but more recently, people are able to file they're able to file federal lawsuits for medical malpractice in the military. So I would expect to see less 1151 claims moving forward. It's already a claim that's not filed very often, but I expect that this will actually reduce them. So we're going to briefly talk about military sexual trauma. And I realize I'm moving kind of quickly through all these materials. We'll take a break here shortly to answer any questions, and then hopefully I can answer your questions again at the end, more questions that come up. But we're about halfway through the presentation, and we're 30 minutes in, so we're making good time. So we'll talk about military sexual trauma. This could be any stressor or experience or anything that was caused by some type of sexual assault, sexual harassment. It even involves text messaging. There could be an offer for a quid pro quo from a supervisor. Any type of experience that is sexual in nature could qualify as military sexual trauma. And you can imagine, I mean, it's very common. It's very, they happen very frequently. The reality is the military is still a male-dominated profession, and there are a lot of different situations that take place in the military that would not ever take place in most places of civilian employment. That still happens. The military's gotten a lot better with it, but it is still pretty common. And also keep in mind that it could affect somebody of the LGBT community. It doesn't have to be, a male who sexually assaults or sexually harasses a female. It could be an individual who is sexually harassed or sexually assaulted assaulted because of their preference or something like that. So all of these different situations apply. So establishing service-connected compensation for MST, I did talk about this briefly right at the beginning of the presentation. You have to have some type of medical diagnosis. An MST is an experience, not a diagnosis. You have to have some type of diagnosis tied to that MST. What we see most often are PTSD, anxiety, panic disorder, depression, sometimes all of these. And what we say is claim broadly. So if you're filing a MST claim, you want to claim all of these things if you can. If they apply and the veteran has any or all of these things, claim them all, claim broadly, give that individual the best opportunity to have one or more condition service-connected as a result of that MST, and you should improve their chances of getting a favorable outcome. Here are the elements. They're slightly different than the prima facie case for non-MST claims. You have to have evidence of a current diagnosis. So again, PTSD, anxiety, panic disorder, something like that. And you have to have credible evidence of a stressor. So it's a lot easier to show credible evidence of a stressor than it is to, provide medical records and everything else, the different elements for a prima facie case. So credible evidence of a stressor, that could be a statement from somebody that the individual complained about the action to. That could be some type of proof that quid pro quo was made, or it could be text messages. It could be any type of evidence that would provide credible evidence of the stressor, the MST, that the actual MST experience took place. That evidence is almost always going to be admissible. And then you have to have that link or nexus between the two, which is a very easy, very liberal standard in this type of case. So we talked about diagnosis required, experience, not the MST itself is the experience, not the diagnosis. So you need an actual condition. We talked about claiming broadly, just repeating those issues there. So what are some forms of credible evidence of the stressor? The VA is going to look for markers, or, the markers are considered to be credible evidence of the stressors as well. And there's a list that you can see. It's not an exhaustive list, but I did put a citation here for the list. But then these are just some forms of markers that the VA is going to look for. It could be police records, it could be medical records, it could be an STD or pregnancy, it could be statements from friends, family, roommates, anybody who saw it. Could be that spontaneous, the person that veteran reached out to immediately after it happened and complained to. That person could submit a statement. There's a number of different markers. Something to consider is that it could be years after that incident took place. It does not have to be immediate, and the VA is not going to hold that against the veteran, because we all know that people who are put in this situation don't, automatically come forward and complain about it. Sometimes they're uncomfortable doing so. They might have feared for their safety. They might have feared for their career. So it could be years after the incident took place, and now the individual is coming forward and filing the claim. That evidence is all still going to be considered credible evidence. And we have to have the link or the nexus. So they're going to want to see a link between the diagnosis and the stressor. And again, that's going to be a liberal standard. All right. So I'd like to open it up to questions right now, but just keep in mind that the next half of the presentation is going to deal with filing your claim, appealing decisions, calculating the amount of money that the veteran is going to obtain, and determining what the percentage is for those claims. So any questions about those issues I can answer when we're done with the second half of the presentation. Are there any questions about any of the material that we've covered so far?
Anthony, I don't see any questions submitted yet, but we'll give them a second.
Okay.
There is one question, well, a couple questions. How do I follow up on the status of an application for a VA pension?
Application for a VA pension?
Yes.
Okay, so that's not a form of service-connected compensation. I'm not going to get too into detail on a pension claim. A pension is for an individual who served, at a certain period in their military career, would qualify them for a pension. and maybe they don't have a retirement otherwise, so they can apply for a pension. Usually, the easiest way to follow that along, there's a couple of different things you can do. You can meet with a VSO and sit down, give that individual power of attorney through filling out that 2122A form, and then that VSO takes them a couple of weeks to get you into the system, and then they can usually see your application. They don't charge you, so that would be VFW, DAV. Locally, there's a VSO that the state has at Western New York Heroes. He's pretty helpful with these types of things. You can fill out your paperwork and have a VSO basically take over as your power of attorney, and then they can follow your case along and give you status updates. If you don't want to do that, you can go on to eBenefits. It's a website. I believe it's eBenefits, and they recently changed it to .va.gov. But if you Google eBenefits, you'll be able to go onto that website, set up an account, and you should be able to track any of your claims and the status of any of your claims that way.
Okay, I'm sure this kind of goes along with it. As far as VA pension, what is the process for changing over aid and attendance when someone enters a nursing home? That's something.
Changing over a dependent for what? I'm sorry. I didn't.
Changing over aid and attendance when someone enters
aid
a nursing home?
So aid in attendance is a special type of compensation where the individual gets additional compensation above and beyond service-connected compensation. Maybe they can't bathe themselves, or maybe they can't feed themselves, things of that nature. That money is going to go to the veteran. So I'm not really sure who it will be changed over to, but the veteran obtains that additional income if they need. And the idea behind it is they're going to have to pay somebody to take care of them. So the money should go to the veteran. If the veteran has a fiduciary or somebody responsible for their finances, that individual would have access to the bank account and would be paying the bills on the veteran's behalf.
Okay. That's all we've gotten so far. So if you want to move ahead and we can see what else we get.
Sounds good. Will do. Thank you.
Thank you.
Okay, so we'll talk about determining the percentage that an individual will receive from the VA. Now, there is a citation here for the schedule of rating disabilities. You can go in there and look at the many different medical conditions, and the VA breaks them down in some type of 10% increment. Each condition is slightly different. So for some of them, they might go 0, 10, 20, 30. For others, they might go 0, 10, 20, 50. So each condition is slightly different. I know PTSD, for example, has some pretty big jumps. They don't go every 10%. And once you get these percentages, that's going to be used on the chart to determine how much money the veteran's going to get every month. And I'll show you how to do that here shortly as well. But the VA is going to consider the diagnosis, anything that was determined to be service connected. And then they're going to take that condition, they're going to look at the severity of the symptoms, they're going to match it up to their definitions for each percentage, and they're going to assign the percentage that way. So you don't have to have all of the symptoms for the higher percentage, you just have to have some of the symptoms of the higher percentage. And this is that gray area where the advocate can sometimes appeal and get a higher percentage because they can argue that some of the conditions exist. It's not required that all of the conditions exist. So, the 0%, that's not a mistake. For those of you that don't know, the VA will sometimes assign a service-connected compensation at a rate of 0% for a condition. That means that the VA they've considered the condition to be service-connected, but it doesn't rise to the level of whatever the definition of 10% is. So the individual is not going to get that monthly check. But what they will get is they will get treated at the VA for that medical condition or any medications that are required, and it will be at no cost to the veteran. So the 0% is a win. And another reason why 0% is a win is because in 10 years, when that condition worsens, the veteran can file a claim to upgrade or to increase that percentage. And if the condition did in fact worsen and the veteran has some new symptoms, it's already a service-connected condition. They're going to increase it based on the severity of the condition at that time. And, I call it VA math. A lot of people call it VA math. VA math is going to piss a lot of your clients off. It's very difficult. It's very confusing. I'll show you how to do it here shortly. There are charts on the website. So if an individual has, we'll say 4 conditions rated at 10% each, they're not going to get 40%. And that is going to cause them to call you and yell at you, and they're going to be angry with you because a lot of them aren't going to understand that the VA doesn't add them all together. The VA uses their formula, what we call VA math. I'll show you how to use that formula here shortly, because I think the formula actually is easier to use than the charts that the VA provides. The charts can be a little confusing. We'll talk about that in more detail in a minute. But we talked through, how the VA assigns a certain amount of money. Again, they get their percentage based on the severity of the condition. They assign, and then you use the percentage to determine how much money the veteran is going to collect on a monthly basis. And that information is right on the VA websites. So this is just, the procedure for how the VA does it. So this is an example of a condition that the VA could consider for service-connected compensation. So this one is migraines. Each conditions have that four number code, and then the medical condition itself or the diagnosis itself is associated with that medical code. So you'll see that code listed on some of the VA paperwork. It helps you look up to make sure that they got the right percentage. But for this one, 0% for migraines would be just migraines with less frequent attacks. So, the individual has migraines. They're not significant, they're not frequent, but there are migraines. They're service connected because the individual hit his head in basic training or something, and they're going to assign a 0%. And then as it gets worse, so now you have these attacks averaging 1 in 2 months over I think it's 1 or 2 over the last several months. I think there's a typo there, but it bumps it up to 10%. And then to get up to 30%, you have to have on average once a month over the last several months. So this is the definition of each percentage. And depending on the medical condition, sometimes like PTSD, there might be bullets. They have a whole bunch of different possible symptoms, and you want to be able to try to argue for the higher percentage based on the symptoms that that veteran's suffering from. And this is where the percentage comes from. This is the VA math that I told you we would talk about. So I'll talk through it. We'll take a little bit of time on this. I'll talk through it slowly because it can be confusing if you haven't done it before. And again, if you guys have any questions, we can follow up after the presentation, or you can follow up with me separately and I'll help to explain it. So in this specific example, we're going to say that the veteran has 3 conditions. Really doesn't matter what the conditions are, but they rated them at 70%, 50%, and 10% disabling. So again, my math is off there. That should say they add up to 130%, not 110%. But if you added them all together, that gives you 130%, and the veteran's going to say, I have 130%. The veteran's not going to have 130%. In fact, the veteran's not even going to end up with 100%. And you have to be able to break down the math to explain to the veteran, because they're going to be pretty fired up in most cases when they see that they're not even at 100%, even though their disabilities add up to 130%. So here's how the formula works. The first condition is going to be the highest percentage of all of the assigned percentages. So in our example, condition 1 is going to be the 70% condition. So the VA is going to take 70% away from whatever is existing for, we'll call it the veteran's health. So prior to these conditions, the veteran is 100% healthy. 70% of 100% is 70. So you can subtract the 70 from that 100% health, and it brings them down to 30% health. So now the veteran is only 30% healthy. So our next condition is going to be a condition that was rated by the Department of Veterans Affairs at 50%. So we now know that the veteran is only 30% healthy, not 100%. They're 30% healthy because we took that 70% away. So 50% of the remaining 30% is going to be half. It's going to be 15. So we take the 30% because that's what we have remaining. The veteran's 30% healthy minus the 15 for condition 2 gives that veteran 15% remaining. So now our veteran's only 15% healthy. So condition 3, we take 10% of 15, which is 1.5. So now our veteran who is 15% healthy subtracts 1.5 from the 15, which brings them down to 13.5% healthy. So the Veterans Affairs rates to the rounds to the closest 10. So essentially our veteran is 10% healthy. And we're going to go back to 100% minus that 10% healthy means our veteran is 90% unhealthy or 90% disabled. So the veteran who has, well, it should have added up to 130%, has 90% disability rating. I hope that made sense to everybody. I hope the math here makes sense to everybody. Again, let me know if it doesn't, and I'll be happy to explain it in more detail. But then there's also a chart on the VA website. It's easy to use for 2 conditions. Once you get beyond 2 conditions, it's pretty difficult to use. And the way they do it is they ask you, what originally it's 100%, right? And then your new condition is, in this example, 70%. So you come down to 30%. So they take the 30% on the second chart and they say, what's the new condition? So you have 30%, new condition, in here was 50%. So you go 30 and 50 and you come together and it gives you 15%. So the charts work that way. It just gets confusing with multiple medical conditions. So it's easier to be able to use the formula. There are many different types of additional compensation. We're not going to get into them in any detail because there just isn't enough time in this presentation to do that. But just know that you could obtain more than $8,000 a month in service-connected compensation. Now, 100% VA service-connected compensation, 100% is just over $3,000. But with the special monthly compensations and the other types of benefits, you could get that number to up to over $8,000. And that would happen if the individual is bedridden, loss of use of limbs, they qualify for special monthly compensation, aid in attendance, they're blind, different things like that, where they might require additional funds to be able to live their life. There are also grants for home adaptation. There are automobile grants if the individual needs a certain type of automobile. So there are all different types of benefits that veterans could apply for. These big numbers, they're common. I have a note in here that they're common for individuals with MS. They are very common for individuals with MS, but what's also common is people with MS, the VA often sends out investigators and they'll take pictures of them going to get the mail from the mailbox, and then they'll pull them back in and they'll allege fraud. Sometimes they will actually pursue criminal charges and individuals get put in prison over this. So make sure that if your veteran has MS, that they're very clear and very honest in all of their doctor's appointments. Make sure that they don't embellish the condition because they could find themselves in prison and owing hundreds of thousands of dollars if they do embellish the condition. So these are just a couple of things related to determining that percentage or how much money the veteran is going to get. The VA avoids pyramiding. So if there are multiple conditions that can be, that are essentially the same condition, but there are multiple different conditions that got assigned a percentage for that condition, the VA is going to consider the highest, percentage, and they're going to assign that percentage for that condition. Now, if it affects different parts of the body, or you can separate those conditions, sometimes that's where the attorney or the advocate comes in, is you want to try to be able to separate those conditions and argue to the Department of Veterans Affairs that they're not pyramiding. These are separate conditions that cause separate issues. And sometimes you'll win those cases, sometimes you won't. But the VA is going to try to avoid pyramiding, and they're going to just attempt to assign the higher rating if they think that 2 conditions are related, or 2 diagnoses are related to the same condition. And that's what all of this says here. So eligibility for this is total disability, individual unemployability. So we've talked about the percentages, and like I said earlier, an individual collecting 100% is usually just over $3,000, and it can grow if they have children or a spouse. If they have any type of dependents, that number increases based on the number of dependents. But one way to get an individual paid at 100% is to apply for TDIU. So the main standard here is that the individual is unemployable. They cannot obtain and maintain meaningful employment or gainful employment. So here are the requirements for it. The individual must be rated above 60% for one specific condition, or they can have a combined 70% or higher. Usually what you see here is an individual has 80%. That's the most common number that I see with TDIU claims. The individual is 80% disabled, and we will file to get them TDIU. If you establish TDIU, it bumps them to 100%. So instead of, and it's a significant jump. If you look at the charts, it's a really big jump from 80% to the amount of money that they get on a monthly basis is a really big jump from 80% to 100%. But the main concern there is that if you're rated at 100% without TDIU, you can work, you can have a job, you can have income. It doesn't matter how much income you have. If you're rated at 100%, that's it. You get your 100%. You get your $3,000 a month. If you get TDIU and you have 80%, but they bump you to 100% as a result of the TDIU, then once you establish, gainful, meaningful employment for the required period of time, they're going to kick you back down to 80%. You don't just continue with the 100% because you're not unemployable. So that's the difference between the two. And here's how it works. So they call it substantially gainful occupation or employment. They want to see that you're not exceeding the poverty threshold or that you're over the age of 85 or 65, I'm sorry. So for anybody over the age of 65, as insulting as it might be, the VA considers you unable to obtain and maintain substantial gainful employment, which works in favor of the veteran, even though we know that it's a presumption that obviously is not true. But it's a presumption that works in favor of the veteran, so we'll use it. You want to be careful not to demonstrate an ability to earn more than the poverty threshold if the individual is on TDIU. And the funny thing about this is I've personally worked cases where the veteran argued with me about whether they were unemployable. They told me that I'm not unemployable, and I have to tactfully say to them, well, you haven't had a job in 10 years. And they want to argue. And I actually had an individual argue at the hearing one time to the judge that I didn't know what I was talking about and that he's able to be substantially gainfully employed. And I said to the judge, with all due respect to my client, Your Honor, the record does not reflect that that's the case. So I don't mean to be, my client's interests right now are what I'm here for, and it is in his best interest for me to tell you that he is not able to obtain or maintain substantial gainful employment. And as aggravated as my client was about me saying that, he had, I think, $150,000 hit his bank account maybe a few months later. So he was no longer mad at me. But, the judge obviously agreed. And to date, that individual still has not been gainfully employed, even though he tries very hard to be. It doesn't work out because of some of the conditions that he has. These are circumstances where the VA may reevaluate a rating. So under some circumstances, it can be easy for them to do, but if you have certain conditions like TDIU or things like that, it can be difficult for them to reduce your rating. So the way it would work is the individual almost always is entitled to a hearing so they'll get notification and then they can respond, have a hearing. And at the hearing, you'll see down there at the bottom, there must be an examination before the hearing that shows that there's a material improvement under ordinary conditions of life, and that just a change in symptoms alone is not enough to reduce an individual's rating. So, take a look at that in more detail when you go through the slides, but this explains what the VA has to do if they want to try to reevaluate and reduce your client's compensation. Again, these are just some protections or some presumptions that apply. There's a 20-year protection. If an individual above that is just briefly, there's the substantial gainful employment. It has to be at least 12 months in order to reduce the veteran's TDIU claim. So that's what that's in relation to. But below that, if a veteran is rated for 20 years or more, the VA cannot conduct a reevaluation and reduce the rating to any number lower than that of the lowest rating in the past 20 years. So what that means is if the individual for the past 20 years has been at 100%, that's it. They're at 100% for the rest of their life. If they're at 100% now, but at some point in the past 20 years, they were at 80%, then the VA could potentially reduce them to 80%, but no lower. And then you have the 5-year protection here, which is a little less protective, but it's still a protection that works in favor of the veterans. The VA can't reduce the rating based on a single exam unless all evidence shows sustained improvement. And the way that you can beat that is by, going to, sometimes the VA will, there is, at least a group of people who believe that sometimes the VA will develop evidence to be able to deny a claim because they just don't agree or whatever is going on, and they'll make it difficult for the veteran to establish their claim. It's called develop to deny. Feel free to look it up. There's stuff out there on it, but you can get a private doctor to do an evaluation as well. So sometimes the private doctor doing the evaluation can be beneficial for your client. So these are just some of the recent changes. This is for the appeal process, and I'll talk through this quickly here, but you can find all the information on va.gov as well. Legacy's out, so that was where you filed a notice of disagreement within a year of the decision. There's no longer a notice of disagreement. Instead, there's a different document based on the type of appeal that you're going to file. These are now the types of claims. There used to be a new claim which had a different meaning. These are the forms of claims that you can file now at the VA. So your original claim means you have no service-connected rating. Increased claim means you're trying to increase the percentage of an actual existing condition that you're already rated for. A new claim now means, a new claim used to be the original claim, but a new claim now means you're just trying to add a new condition. You already have service-connected conditions. You're trying to add a new condition to the list. Secondary claim, we talked about, that's where a new condition comes up as a result of an already service-connected condition. And then a supplemental claim, that's where essentially you're trying to supplement the record because a claim was previously denied. You're adding additional evidence to the record. So this is the link. If the VA still has it up, avoid it. I put it on here not for you to use, but I put it on here to show you that was the legacy appeal process, which ended on February 19, 2020. It no longer applies. They're slow to take this stuff off of the internet, off of their websites. Do not use it, because if you file a notice of disagreement and miss a deadline as a result of filing the wrong document, it's going to be very difficult to go back and get a new retro date for your client. Your retro date is the date you file the claim. The VA will pay the benefits all the way back to that initial date, as long as you don't miss any filings or deadlines during the period. And again, sometimes it can be 5 to 8 years, and it can be hundreds of thousands of dollars. The biggest one I've had is right around $300,000. So make sure you don't miss any deadlines or dates, and the VA will backdate it all the way to that original retro date. So you have to make sure you're using the correct form, and each of these here under the Appeals Modernization Program have their own form. So a supplemental claim, this is the form that you would use. That's where you're going to add new and material evidence to the claim. A higher level review, that's where you're just basically appealing that lower level denial and asking for somebody at a higher level to review. And this is the form that you would use. It's in there in the title. And with this one, you're supposed to get a de novo review, and you're also supposed to get a right to an informal conference, which the VA does not work as hard as they should to schedule, but there's a possibility that you'll get the informal conference. There's supposed to be a right to the informal conference. You might have to fight to make sure that that happens. And then you can also appeal to the BVA from either the supplemental or the higher level review. It makes it a little easier to get to the BVA now, a little quicker. That's the Board of Veterans Appeals. That's where you'll go and sit in front of an administrative judge. It's really a fact-finding hearing, and then all of the evidence will go forward to the board, and the board will make the decision. The judge doesn't make the decision on the spot. This is your opportunity to appeal to the BVA. You usually have 120 days to do so. And that'll all be explaining the decision letters that the VA, that the veteran receives from the VA. The timeline's in there. It's all explained pretty well in there. Just some general procedure, comments for the Court of Veterans. Court of Appeals for Veterans Claims, you should know that this is an actual federal court. It's like the Court of Federal Claims. It's like district court. You know, there are court rules. There's a website for the court. You have to be admitted to the court. It doesn't matter if you're accredited. You actually have to be admitted to this court. So you have to treat it just like a federal court. So this is not going to be that administrative law that's easy and you know, that the VA practices. This is an actual federal court. So your briefs are thorough. There is a, you know, scheduling. There are going to be conferences, things of that nature. So it's a lot more in depth than just filing an administrative appeal. This is just, I threw a couple of things in here at the end just to give a little bit more information. So dependent indemnity compensation, this is for the spouse. They could be entitled to some benefits. The surviving children could be entitled to some benefits, depending on their age and whether they're in school. This is how it works. But again, this information is going to be also in more detail on the va.gov website. And survivor pension eligibility, this goes back to the, there was a question asked about the pension earlier, but this is a survivor pension. So a spouse could potentially be entitled to a pension as well, as long as his or her income is less than that. When I did this, it was $12,907 annually. It changes. So, but the cutoff is around the poverty threshold, and they have a net worth of less than $80,000. All right. That's it for the presentation, and we went 1 minute over. How about that? Does anybody have any questions on any of the material that we just covered?
This is something that you just covered, but someone did have a question. I don't know if you're able to provide information on how someone goes about getting aid in attendance.
Sure. So in my opinion, the best way to, there are multiple different ways that you can actually file a claim. And if you go, just type in file a claim for service-connected compensation in Google, and it'll take you to the va.gov site. Ignore all the ads. The first group of you know, sites that are going to come up are going to be ads from attorneys or other people trying to get money from you to file the claim. You don't have to do any of that. So type that in, look for the va.gov site. It's going to give you a rundown. You can file by email. You can file by mail-in application. You can file a number of different ways. In my opinion, the best way to file is to do it online. So you can go on va.gov or eBenefits and file your claim that way. You're going to get asked some preliminary questions, and then that will direct you as to whether you should proceed on va.gov or eBenefits. And you're going to get to a point in the application where you're going to get a drop-down menu that's going to have a whole bunch of medical conditions. And I tell veterans to do this. It's better, in my opinion, than going to sit down with an attorney or anybody else and have them file this paper application. This is the best way to do it because you get the drop-down menu and you'll see all of these medical conditions that if you and I sat and talked about, you would not think to tell me about. So thyroid disease is a compensable condition. Many service members have it, many veterans have it, but they don't realize it could be a compensable condition. There are high blood pressure, believe it or not, is a service-connected condition if it started when the individual was in the military. Doesn't have to be tied to anything. So you get this drop-down menu, and you go down the drop-down menu, you check all of the different conditions that the veteran has, and then they submit their claim that way. And then you know they'll get some appointments set up for evaluations, and they'll continue that way. But that's the same way that you would apply for aid in attendance or service-connected compensation. You can do it right online and go through the online process, which is what I advise, or you can just print the paper application and submit an application for aid in attendance.
Great. I don't see any more questions coming in, so I'd just like to thank you, Anthony, for providing this very comprehensive PowerPoint, and let everybody know that this will be available on our website with this recording at a later date. Thank you all for joining. Please fill out a survey that will pop up at the end of this discussion. It'll be very brief. And I hope that you will join us again next Wednesday for our topic will be on asset protection planning for long-term care expenses. Thank you again, Anthony.
Thank you. Appreciate the invite. Thank you.